Senate Judiciary Committee will come to order. Our first order of business is a hearing on Senate Bill 152, so we will open the hearing on Senate Bill 152. We do have, looks like 4 in-person conferees, so we will limit the testimony time for each to 7 minutes, and if you want to cede the rest of your time, if you haven't used all the 7 minutes to another conferee, you may do so. And with that, we will ask then for the bill brief from the reviser, Mr. Thompson.
Thank you, Madam Chair. Senate Bill 152 provides for joint liability for costs and sanctions in third-party funded litigation. It also requires certain discovery disclosures, and it requires payment of certain costs for non-party subpoenas. I will note that this was introduced in 2020 or in 2021, so it has some 2020 dates that would need to be updated if you were to work the bill in the future. So just keep that in the back of your mind. There would be a minor technical amendment needed to carry this forward for the new session. But to the substance of the bill, you have a bill brief that you can refer to in the future. There's a new section of law, Section 1, that would be part of our Code of Civil Procedure, and it provides that any person other than an attorney permitted to charge a contingent fee for representing a party that has a right to receive compensation that is contingent on and sourced from any proceeds of that civil action will be jointly liable for costs assessed and monetary sanctions imposed on the party with whom that person has an agreement. So if you have one of these agreements that allows you to receive compensation based on a contingent arrangement or sourced from proceeds of that action, you will be jointly liable for the costs and sanctions associated with that action. Section 2 amends KSA 60-226. For any attorneys in the room, that's the non-attorneys in the room, I guess. That's our Code of Civil Procedure section on discovery. So this is how you acquire records, documents, etc. In the litigation process. There'd be a new subsection, B3 capital B, and if you want to find that one, it's on page 2 in line 30. So that new subsection, subparagraph, would provide that except as otherwise stipulated or ordered by the court, a party shall, without awaiting a discovery request, provide to the other parties any agreement under which any person other than an attorney that has a contingent fee arrangement that's allowed. If you have a right to receive compensation that's contingent on or sourced from proceeds of the action by settlement, judgment, or otherwise, you have to disclose that without awaiting a discovery request. It's just an automatic discovery requirement. And then finally, Section 3 amends KSA 60-245. That's our civil procedure statute concerning subpoenas. There would be a new subsection C4 added, and that is on page, I had it marked and I lost my place. That is on the top of page 10, beginning in line 2. And this subsection is specific to non-party subpoenas and third-party funded actions. So again, if you have a party that has an agreement that's subject to the statutes we were just talking about, that has that contingent or sourced from proceeds sort of agreement, if you have one of those, you shall reasonably compensate a person who is neither a party nor a party's officer the cost of responding to a subpoena to produce designated documents, electronically stored information, or tangible things, to permit the inspection of premises, or to appear at a deposition. So if you have one of these agreements, you have to compensate a non-party that has to do any of these obligations under a subpoena. That's the 3 sections, and I'll be happy to answer any questions if you have them.
Thank you. Committee, questions for the reviser? Yes, Senator Thompson.
Just real quick on Section 2, what could you give us an example of who that would be, what that kind of a person would be, Jason?
Go ahead,
with regard to a third party.
Sure.
Go ahead, Mr. Thompson.
Thank you, Madam Chair and Senator. From my understanding, sometimes it's an outside company that does these sorts of things. I think you have some testimony to that effect. But it could also be, you know, it says any person, so any person, business, etc. So anyone who says, I'm willing to sign this agreement with you, and my compensation is based on what you recover so it's contingent, or I only receive money from the proceeds that you receive. So if you have that arrangement, you're under this section. My understanding is that's usually a business that you're doing that with, and I think you'll hear from some of those folks.
So it'd be like an expert witness, for example?
I suppose it could be an expert witness if they had that arrangement. I don't know for sure if those are allowed. So I'll probably just lean on the example I gave, and then both the proponents and opponents, I think, can get into how these normally work in the litigation process. I just don't want to misspeak. I'm not as familiar with it as they are. So
Sounds good. Thank you. Thank you, Madam Chair.
Thank you. Committee, other questions for the revisor? Seeing none, then we will invite our first proponent in-person conferee, Eric Stafford, Vice President of Government Affairs, Kansas Chamber. Please introduce yourself. Welcome back to committee, and I'll start a timer at 7 minutes, and when there's 1 minute left, I will give a warning.
All right.
Thank you,
Madam
Mr.
Chair.
Stafford.
I will save most of my time for Mr. Behrens, who will be up here shortly from the Institute for Legal Reform. Eric Stafford, Vice President of Government Affairs with the Kansas Chamber, here in support of Senate Bill 152 today. We did introduce this bill. The answer to your question, Senator Thompson, is hedge funds. There are hedge funds that invest in litigation, and they invest in litigation for a return on that investment. And that is as American and as capitalistic of an idea to make money as you can get, which is great. And we're not opposed to them making money. We just want to know that they exist. And so we're asking for the disclosure of any third party to the case or costs associated with frivolous lawsuits, if it's determined to be such, that those be compensated. So this bill was introduced again. If you remember our testimony on Senate Bill 150, which this committee approved, we've seen our legal reform ranking slip in conversations with the Institute for Legal Reform, some trends that are going on across the country. This is a bigger one, and so this bill was introduced to try to combat a growing trend. I think in our testimony, it's estimated that it's about a $10 billion industry right now. So, but this 10 years ago, 15 years ago was pretty limited. I think the first white paper focused on Australia, where this was becoming a problem. Then it's kind of leaked across the ocean into America. So I'll save the rest of my time for Mr. Behrens, if that's okay, Madam Chair. But I appreciate the opportunity to be here today.
Sure. Thank you, Mr. Stafford. Appreciate that. And that's about 5 minutes extra then for our next conferee, Mr. Mark Behrens with Shook, Hardy & Bacon, LLP. He's here on behalf of the U.S. Chamber Institute for Legal Reform. Please introduce yourself and welcome to committee.
Good morning. It's Madam Chair, members of the committee. It's an honor to be here today representing the U.S. Chamber Institute for Legal Reform. Third-party litigation funding is a newer phenomenon in the United States, and it has the potential to distort our legal system. And this is a very modest approach to dealing with some of the problems raised by third-party litigation funding. When we talk about third-party litigation funding, what we're talking about are big hedge funds, money managers like in New York, investment bankers in New York, that are putting money into law firms to fund litigation. And these may be speculative lawsuits. And the issue comes when you try to go to settle a case, who is the lawyer's client? Can the lawyer really represent her client? Or is the lawyer really beholden to the New York bankers that gave him the money to fund the lawsuit? And courts should have a right to know when there are parties in a case that aren't at the settlement table. And I'll just give you one sort of brief example of how the dynamic can play out and why it is problematic and needs to be addressed. You know, as a young lawyer, one of the first cases I ever handled was a Jeep rollover case up near St. Joe's, Missouri. Looked a lot like this. It was a lady that had used some marijuana, was drunk driving, drove home with a man in her car that she had picked up at a bar, drove off the road into a ditch. The vehicle rolled, she was thrown out, hit her head, she was killed. Plaintiff's attorney came to me and said, we should settle this case. And I still remember, it was very emotional, even as I was thinking about it coming over today, because he said, you and I know what happened in that car that night. but she left a little boy behind. And she said, but that little boy doesn't need to know about it, what his mom was up to. And we were able to work out that deal because you had a plaintiff's attorney that was trying to do the right thing for a little boy that was his client, and we were able to come to an agreement that was really to avoid the cost of going to trial because we advised our client that they had no liability. This was an unbelted drunk driver that went off the road. But the company did pay money to settle the case because we knew if it went to trial, we'd probably have to spend $100,000, $200,000 just in legal fees to prove that we weren't liable. So there was an incentive on our part to settle. And we were able to get the parties together and work out a fair agreement that protected that little boy, put money in a trust to fund the fact that he's going to need things throughout his life and somebody to take care of him. That may not have happened if there was a third-party funder in the case. And you know why? Because when we sat down and worked out a deal, and the deal was essentially a fair agreement to protect the little boy's interest and my client's interest, that would not have happened if when we thought we had an agreement, that lawyer then said, well, hold on, before I sign the settlement agreement, I need to go make a phone call to New York. Because you didn't know about this, but I've been funded by a New York banker. And before I can sign the settlement agreement, I've got to go talk to that banker and make sure that the terms are satisfactory to them. They don't care about the little boy. They don't care about my client. They have a return on investment that they want to make for their investment in the case. They may come back and say, this isn't good enough for us because we want to return a 20% investment on our investment in this case, and now all of a sudden the settlement cost is going to have to go up 20% to pay us. At that point, if they came to us and said, the cost of the settlement isn't what we agreed to, all of a sudden it's gone up 20% more because we've got to go pay this banker that we never told you about, that deal would have fallen apart. We would have taken that case to trial because we felt there was no liability. That's the problem when you have somebody involved in a lawsuit that's unaware to the parties of the court. And this bill would protect that. It would simply say, let's get the parties together. Let's find out who all the parties are in a case, whether they're parties in a legal sense or in a contractual sense. Put them in a room and we'll be able to work out an agreement, knowing who everybody's involved. And it also will overcome any ethical issues because there's real questions there when that lawyer has time, when it's time to settle. In that example I gave, who is the lawyer's client? It should be the little boy. But is the lawyer really in a position to take a deal that's the best deal for that little boy when he's on the hook for a banker in New York? And so this bill will deal with that in a very modest, free market way. It doesn't ban third-party funding. It simply says there should be disclosure if it's involved in the case, so the courts and the parties know who the real party in interest is, can involve them in the settlement discussions, and make sure that the lawyer that is settling is actually able to make judgments about their decisions and not violate any ethical rules that apply in the state of Kansas. And with that, Madam Chairman, I'd be happy to answer any questions.
Thank you, Mr. Behrens. Appreciate that. And we also then have proponent written-only testimony in your committee folder and online from Hillary Segura, Assistant Vice President and Counsel, State Government Relations, American Property Casualty Insurance Association. Do we have any, before we open it up for questions, do we have any other proponent conferees in the committee meeting room or online? I don't see any. Then, committee, any questions for the proponents? Yes, Senator Baumgardner.
Thank you very much, Madam Chair, and I'd actually like a response from both of our proponents. So there was discussion about this as a trend. I'm not seeing any information that this is actually a trend in Kansas. So do either of them have any information about this being a trend in Kansas?
If either of our proponent conferees would like to answer, please introduce yourself.
This is a
Could you
difficult
please
question.
introduce yourself real quick, just for
Oh,
those
yes.
following online? Thank you.
Mark Behrens, United States Chamber of Commerce. I wish I could answer with more definitive data. The problem is, in this area, because these agreements, these funding agreements are done in secrecy, there is no data on how often they're occurring or when they're occurring, but we know that this is a national trend. A few years ago, we know that it's also used, you may hear that these are just in business-to-business lawsuits. That's not accurate. We know that it is going to use to fund some of the television advertisements you see on TV, and those are running in Kansas. So we have some information that when you see the lawyer ads that run on TV, the national lawyer ads, not local Kansas lawyers, but when people are looking to join on to, mass torts that are being filed in California or New York or Philadelphia, those, and when you look at the fine print on there and they say we're not barred in this state, they're Texas lawyers, we know that that money that is reaching into Kansas is being fronted by these institutional investors that are buying a piece of that litigation. But I couldn't tell you how often or how much because it's all done in secret.
So how do we know, Madam Chair, how do we know that this is actually a trend if everything is in secret? I mean, it's interesting. When I look at the proponent testimony, we all seem to cite what's going on with regard to action in Wisconsin, but I'm not seeing anything to really truly back up this whole aspect of this is an $11 to $12 billion industry, because the citation simply says they're estimates. So can anyone share with us an actual example? And I guess the other question is, so what really is the harm? What are the harms to Kansans? I heard the scenario that you shared, which sounded pretty much like a personal injury story. And I'm not seeing any evidence shared with us with regard to third-party litigation being personal injury. So there's a trend that no one can document because it's not transparent, and yet this seems to be a nationwide push on behalf of the U.S. Chamber Institute for Legal Reform. And yet, so talk about the harms and talk about, I don't see that this would necessarily impact the story that you shared that would be personal injury. And I guess if you're going to go that way, that it would be a personal injury story, I see some holes in that story, because obviously the little boy that you spoke about at some point could get the report from law enforcement for that accident where his mother was thrown from the vehicle. But just as likely is you could have a third party, like parents could be funding for the attorney, or oftentimes attorneys will negotiate, but they will have to pause and say, oh, well, I'm going to have to contact the people that I represent to see if they're willing to settle for that amount. So that second phone or that additional phone call often seems to be a process when trying to settle out of court. So what are the harms? What are the harms that we know are specific to Kansas? Does it include personal injury? And what is the harm for making an additional phone call? I'm not seeing that.
Madam Chair, Senator, I think the harm is that a lawyer has an ethical obligation to zealously represent the interest of her clients, and that's compromised when there's a outside funding source in the case, because the lawyer knows that if they don't play ball with the funder, they're not going to get funded again. And so it may be in the best interest, let's say in the little boy scenario that I gave, it's in the best interest of the little boy to have
Before you go to the little boy scenario, share with us the issue at hand today. Will that include personal injury?
This is the issue at hand, because in that case, the little boy's interest is in reaching a settlement so that he's taken care of throughout life and having a deal. And what I'm saying is, when the lawyer may represent, you can't serve two masters. A lawyer can't serve the little boy and the banker in New York. And that's what happens in these types of cases. And the reason that it could affect the little boy in an adverse way is that if the funder demands more money, then the defendant says no deal, and they take the case to trial. If we were put in a position of having to try that case, I think the company would have won. There was a very large likelihood that boy would get nothing. And so, that is the problem here, is that the lawyer cannot serve two masters. And at least through disclosure, you can find out what the funding agreement says, and the funding agreement should make clear that the lawyer calls the shots, and the lawyer's obligation is to his client, the boy, not to the banker. And I think if you don't have that, there's always a risk that the lawyer's allegiance tends to tip towards the funding source, because we all know that what's the golden rule? He who has the gold makes the rule. And so, I think that's the danger here. And we do know that it's occurring, and we know that this is a growing industry. All you have to do is, although the funding sources are secretive, some of these companies are public companies. Burford Capital is a publicly traded company. They put out an annual report every year where they boast in their annual reports and in their investor materials how fast they're growing. They're growing by leaps and bounds. So there is some information about the growth of the industry, and it is, if you look at their stock going back to when they first became public, it looks like Apple. I mean, if I had invested probably on day one, I wouldn't need to be here today. That shows you the growth of the industry. So it's happening. The ads are reaching into Kansas, but I'd also say that this is something that Kansas should get on top of, because this is a trend that we're seeing more and more across the country. And it would, we'd recommend that it's a good thing for Kansas to get ahead of this and deal with legislation before it becomes even more of a problem.
Madam Chair, I would ask again that someone would address.
Senator, real quick.
I think we have that coming.
Real quick, Senator Eric Stafford, Vice President of Government Affairs with the Kansas Chamber. First off, a point that was made about parents helping out with the litigation. Unless those parents have a contingency fee, then they don't have to disclose. Same thing for nonprofits. If you have a funder that funds your lawsuit, that we want to help you pursue something, and there is no contingency fee arrangement, then it is not required that they be disclosed. So to the point about the parents of that case being able to help pay for an attorney, they're not falling under this, okay? Second point being the legislature often acts to get ahead of negative trends. This is not unique. We passed something in 2013 when we were told it was anecdotal, it's not needed, it's only Portland, it's only Connecticut that are passing minimum wage increases or paid sick leave mandates on businesses. The legislature proactively passed something that was not specifically happening yet in Kansas, but then 3 years later became part of a party's platform in the presidential campaign. So I think being proactive against negative anti-business efforts is not a bad thing. What is the trend happening specifically in Kansas? We don't know yet, to Mark's point, but I can tell you that this wasn't, we asked the chamber for help on ideas, but then this is also something that our ag implement dealers, there's House Bill 2694 that has a hearing tomorrow that was introduced on their behalf that it does the exact same thing, but even more so. It requires these financiers to register with the Secretary of State. It's very prescriptive on what they can and can't do. Ours is just a disclosure requirement. I made a joke with Stephen Durst the other day and just said, our bill looks pretty good compared to that one. So we're just asking for disclosure that they exist. So how big of an issue is it in Kansas? We don't know. But does that mean that if something bad's happening out there, we want to make sure that we know how bad it is before we do something? Or should we proactively require disclosure, not that demanding, not that big of a deal, to require disclosure that these third parties exist to these cases and have it disclosed? That's all we're asking for in Senate Bill 152.
And Madam Chair, all I was asking for is, do we have any single example of this occurring in Kansas? And so far, the answer is no. This other question that I asked is, the example that was made by Attorney Behrens was a personal injury. So would personal injury lawsuits be involved in this particular issue? Don't have an answer for that yet. Or do you have an answer for that now?
The answer is yes.
So if someone didn't have the funds to take on a lawsuit and they went through this process, as long as there wasn't a contingency, it would not have to be reported. But if it wasn't, if you were to obtain an attorney and not have a third party, is it presented during the case that there is a contingency? Is that normal process? I don't believe it is it?
Mr. Behrens?
Madam Chair, Senator, the normal process typically in any law firm would be to go get it, if the lawyer needs funds to front the expenses in a case, would go to a bank. I mean, our law firm has a line of credit. A normal bank loan is not covered. You go to a bank where you get normal interest rates that apply, and you're on, and the lawyer is obligated to pay back the bank when they win the lawsuit.
Well, I understand.
Those are not also.
That was not my question. My question was, if I hire an attorney, and the attorney says, I will take this on, and this is my contingency, is that required to be reported to the courts, the contingency agreement that I have with an attorney?
Madam Chairman and Senator, no, but because you're representing the client.
I understand.
So,
that was just my question.
Right.
And my only other additional ask, Madam Chair, would be that, that Mr. Behrens, you would resubmit testimony. Because when I look at your testimony, it starts with, thank you for the opportunity to testify in support of Senate Bill 252, asbestos lawsuit disclosure legislation. And so I would like that to be corrected for us, for our consideration. Thank you, Madam Chair.
Thank you. Senator Haley?
Thank you, Madam Chair. You reference Wisconsin, you reference Texas. I'm just curious as to if those two states have done anything proactively. I don't know if what we have before us is tailored after maybe some model legislation that has already been adopted in places that you cite. Wisconsin, I know we heard the case, in Texas. And if in fact there's something that we can use as a framework for how effective it was, not only in its drafting, but in addressing what you've done, which area, which state that might be.
Madam
Thank you.
Chairman,
Mr. Behrens?
Senator, first of all, I want to thank the Senator for pointing out this is lawsuit disclosure legislation, and when I was writing it, I had just testified on an asbestos disclosure bill. So I had two things on my mind. It proves the point that you can't serve two masters, I think. I will get that corrected today. Senator, the disclosure language in this bill, to me, looks just like what passed out of, was signed into law in Wisconsin in 2018. And it is narrowly written, again, to deal with contingency fee agreements for lawsuit financing, not the traditional. So if a lawyer needs money to front the cost of a lawsuit, the traditional path is to go to a bank or go to a parent or somebody else and find the money to do that. That would not be required to be disclosed here or under the Wisconsin Act, because in that situation, the lawyer is not serving two masters.
Thank you, Madam Chair. Thank you, Mr. Behrens. So Wisconsin has something. Do you know of anyone else that does Texas?
West Virginia also, I believe let me see my testimony. In 2019, West Virginia did something similar in consumer cases.
All right. Thank you.
Thank you,
Madam Chair.
Thank you, Senator.
Thank you. Committee, other questions? Senator Corson?
Thank you, Madam Chair. I really appreciate it. So a question about Section 1, you talked about 10 times about New York bankers and hedge funds. But what Section 1 actually says is it says any person, would you be okay with an amendment that says New York bankers or New York hedge funds? Because any person is very, very broad, and you've referenced New York bankers and hedge funds about a dozen times, and if that's really what your intent is, would you consider that to be a friendly amendment?
Mr. Behrens?
Madam Chair, Senator, it needs to apply to any, because these companies could also be based in Chicago or London or Australia. Burford, I believe, is a worldwide global investor. There are others that are worldwide investors, and we just believe that a court should know if a global worldwide investor or one that's just based in New York is involved in controlling the aspects of a case.
So what if we
that
just
should be
said
disclosed to a court?
What if we just said like hedge funds, bankers, or investors? Would that be a friendly amendment? Because what my concern is when you say any person, then you're talking about friends. You're talking about if for example, if a physical therapist says to a person who's been injured, I will provide you physical therapy and rehabilitation services, and I'm not going to ask for any compensation, but contingent on your recovery, I would like to be remitted the fair value of the cost that I've given you. That, if we said any person, to me, that would be covered. And I think that may be above and beyond what even your intent is, but I'm curious. That's my question, because I don't know that we want to stop those things. Same thing if a doctor agrees to provide treatment to somebody and doesn't seek any compensation, but does ask for contingent on recovery to be remunerated. I mean, I'm wondering if the Hospital Association, KMS, if others are aware of this and what to me are very, very broad implications of this. This is not just a hedge fund bankers investors thing. This is a very, very broad provision when you start saying any person.
Madam Chairman, Senator, I think the issue is that all of those other scenarios that you mentioned are out in the open. If a plaintiff is going to a physical therapist, certainly part of any discovery in the lawsuit is going to be what therapy are you going under? And you're going to sit down, you're going to depose the doctor, you're going to depose the patient. The lien, the medical lien is going to be part of the medical expenses involved in the case. So, those disclosures are happening today. What would be new under this legislation is finding out who else is behind the curtain that we don't know about. Is there somebody that's controlling the shots in here, whether they're a New York investor or anybody else?
So your answer is no, you wouldn't consider that a friendly amendment. You want to keep it any person.
Madam Chair, Senator, we believe the language is good as it is in the bill right now.
And my next question is going to what Senator Baumgartner raised, which I thought was a very good point. I mean, the example you gave, one, it's St. Joe, which is in Missouri, so you didn't even have a Kansas example. Two, it didn't even involve litigation financing, so you couldn't even find an example that actually has anything relevant to litigation financing, which is the purpose of this bill. And three, you could easily argue those same facts the other way, that what this litigation financing agreement, had one been in place in your example, what it would have done is it would have leveled the playing field so that when you're going up against a deep-pocketed defendant, which would have been your client in this case, where this person could have not had to, and I know your clients are all benevolent and they're all wonderful, but other people could have been forced into and pressured into a settlement if they didn't have a litigation financing agreement, because they would have not been able to continue on and pursue discovery because they needed whatever they could get from the defendant as soon as they could get it. So they would have had to take one of the first settlement offers they received, because they wouldn't have had what the funding agreement would do is allow them to get all of the discovery, to go through the process, to more fully look at whether or not their claims are meritorious and what might actually be a fair settlement. So I think you could argue the exact same facts that you presented, which again weren't really relevant at all, but you could argue those in a very, very different way. I'll let you respond to that, and then I have one more question.
Madam Chairwoman and Senator, another way to level the playing field would be through traditional financing means, a bank loan. This is how most personal injury lawyers, most other lawyers, and firms, even a big firm like ours, fund their day-to-day activities until clients pay the bills, until settlements come in. So the playing field is level today. There is a way to get there. The only difference is that by having a bank loan come in, the lawyer, when they sign that contingency fee agreement, their obligation is only to that little boy in that example. It could have just as easily been across the border in Kansas. But, you know, when you have third parties that are involved in the case, the ethical dilemma comes when the lawyer then is asked to serve two masters. And that doesn't happen in the traditional financing approach that happens today. It only arises when you have these third-party investor contexts.
One last question, Senator Corson.
Thank you, Madam Chair. And then I'm wondering why we don't have a little bit better balance if that's what we're seeking. So, I mean, I'm looking at the insurance agreement. Said insurance agreements, a party may obtain discovery of the existence of an insurance agreement, but it makes third-party agreements, it says a party shall disclose those. So I'm wondering why all of the obligation for disclosure is all about the plaintiff. And wouldn't it make it fair for that little boy for defendants to have similar obligations to disclose about how defenses are being paid for? If what we're saying is disclosure is the best disinfectant, and we'll just put sunlight on this and that's the best disinfectant, why are all the obligations in this bill so one-sided? Why are all the obligations on plaintiffs and not on defendants? And then I'll just close with, you know, the fact that if we needed any other evidence that this is just a cookie cutter, you know, flown in from DC thing, the fact that this references the wrong Senate bill and talks about asbestos, I would have expected
Committee members will be respectful of our conferees.
a lot better from your firm.
Thank you.
Thank you, Madam Chair.
Go ahead, you can answer the questions.
Madam Chairwoman, Senator, it's a typo. What can I say? It happens. If you get through the day without making a mistake,
What
God
about
bless
the
you.
disclosure and balance? I don't want to lose my last question because that's an important one.
The disclosure, again, Madam Chairwoman, Senator, goes to who's controlling the litigation. And that's all that this bill is trying to do, is have disclosure to find out who is controlling the litigation. The lawyer should be in control of the litigation because it's a lawyer's ethical obligation to represent the interest of her clients. And that's what the bill is getting to, is simply, can the lawyer meet her ethical obligation to her client, or is a boundary being crossed where the obligation is really a financial one owed to an outside global investor? That doesn't come up in the insurance context or in the family loan context, traditional bank loan context. That's why I think the bill is written the way it is, and it's solving a particular problem that doesn't come up in any of the other types of contexts, Senator, that you've raised.
Thank you. Yes, Senator Gossage. We have just a few more minutes before we have to move on. Go ahead, Senator.
Thank you. I have a very short question, Madam Chair. Thank you for being here, sir. I'm going to ask a question that was in written proponent testimony. It says this adds to the state's already significant tort tax on households and drives up the costs of products, services, and insurance. It also redirects monetary damages awards intended to compensate claimants for injury, which I believe what you were discussing. So I'm just trying to understand, what you're saying is that there are entities, hedge funds, et cetera, that can make an investment into litigation looking for a return on investment. Is that what I'm hearing you say?
Go ahead, Mr. Behrens.
Madam Chairwoman, Senator, I'm not sure I find that in my testimony, so.
This was not in your testimony.
Okay.
This was in the written, I apologize, not your written testimony. It was from the American Property Casualty Insurance Association. So I was just asking if you agree with that, or does this make sense to you? And then my second question was regarding my understanding of hedge funds investing in, rather than investing in businesses, but investing in litigation. Never heard of that.
Mr. Behrens?
I think, Madam Chairwoman, Senator, I'm sorry to ask you, could you read the statement again that you're asking me to agree with? Because when you were reading it, I was thinking, I don't recall that in my testimony. So,
No problem.
but I didn't recall having a typo in my testimony either. So if you want to present something
I
that was new to
understand.
me, I was trying to figure that out.
Do we have a written copy of that? He can have my copy if that helps, but there we go. if you want to refer him, Senator, to the passage you're talking about.
Yes, it's in the next to last paragraph, and it's the next to last sentence. I'll just start up here, by turning the civil justice system into a money-making machine, TPLF discourages amicable settlement of disputes and encourages aggressive, prolonged litigation of marginal or frivolous claims. This adds to, and that was where I had begun reading before.
Madam Chairwoman, Senator, yes, I do agree with that.
And then my second question was regarding the hedge funds, and again, this is brand new to me, that there would be hedge funds that would, quote, invest, end quote, into litigation as opposed to investing in businesses or something of that nature. Could you address that? Is that what's happening? That's what I'm trying to understand.
Madam Chairwoman, Senator, yes, this is absolutely what's happening. These are sources with billions of dollars that they could deploy into the stock market. They could buy shopping malls, gold, cryptocurrency. They can invest in anything. And they're looking at the U.S. litigation market as another attractive investment, another place to deploy their capital. And what makes it particularly attractive is that the return on investment can be astronomical. And also, it's not tied to the underlying conditions in the economy. We can have, you go back, I don't think it's the timing of this when third-party investments first started in the United States 10 years ago was right when we were coming out of an economic crisis in the United States, and the government was handing out, was it TARP money, money to help fund businesses that were teetering and real estate. So you have an economy that was collapsing, but the lawsuit world was doing quite well. People are still getting enormous returns. So I think that's what makes this another attractive place to deploy capital, is that it's not tied to if the Russians go into Ukraine this week, the stock market may go down 10%. Well, but not the stock market that's based on lawsuit returns, or not stock market, but not the market for lawsuit returns. So that's one thing I think that makes this very attractive, is that it's a way for investors to avoid typical cycles in the economy and make extraordinary return on their investment compared to what they would do in a normal bank loan.
And that, I have one quick follow-up, and that is, so to get it, I taught elementary school, so I like to get it down for all of us that are listening on a 4th or 5th grade level, if we could. And that is, if a hedge fund is wanting to invest in some litigation in Kansas, how do they know which cases? How does that work? Does the attorney reach out to them and say, hey, I think this is a good case, why don't you invest in this? Can you tell me how that works?
Madam Chairwoman, Senator, no, it's an excellent question. And again, some more information would be known if a bill like this passed. There'd be some more sunlight on this industry. But from what we know, from the reports that they put out, their own marketing materials in the industry, that typically this happens when a lawyer will reach out. But there's been so much money pouring into this space in recent years that the industry has evolved. It used to be where a lawyer would get a one-off case. Somebody comes in, let's say I'm a small solo personal injury lawyer here in Topeka. Somebody walks into my office and I call, one of these lawsuit financiers and say, I want to borrow $250,000 to litigate this case. And if we're successful, you'll get your money back plus 20% return on investment, and you get the first dollars out of any settlement. And that's the way we believe it used to work. But again, there's so much money pouring into this industry now that it's no longer profitable for them to look at these one-off deals here and there, that they're engaging in what are called portfolio financing, where they go to one of these big national firms and they may say, for $50 million or $100 million, we'll buy 20% of all the litigation you have. And
Thank you
so,
so
yeah.
much. That really helps clarify that for me. Thank you, Madam Chair.
Thank you. Just a few points, Mr. Behrens, that I think will help clear up some issues. First of all, defendants usually aren't seeking any monetary relief from a lawsuit, which is why plaintiffs enter into contingency fees, but defendants usually do not. Is that correct?
Madam Chairwoman, that's right. Defense firms like ours are representing clients on an hourly fee basis.
Thank you. And I think some of the confusion might be if you could also explain the return on investment, because a contingency fee often involves a 33% contingency, right? If we win the case for you, you will recover 33% of the award or the compensation or the settlement or whatever ends and resolves the case. And a usual return on investment for a hedge fund might be far lower than that usual 33% in the contingency fee world of litigation. Could you just explain, just very briefly, why we have the development of the International Legal Finance Association and why it would be so lucrative for hedge funds to invest in litigation rather than invest in the market because of the difference in the return on investment, is what I'm understanding the incentive of the International Legal Finance Association to be.
Madam Chairwoman, I think, what best sums up where they're coming at this is in the annual report for one of these larger companies a few years ago. It said, "It may seem strange to think of litigation in this way, but if one strips away the drama," okay, the drama in a litigation are the people, the plaintiff, the injured person, a business defendant. But if you strip that away, then the litigation is nothing more than an effort to get money to exchange hands. That's their view of lawsuits. When I went to law school, my view was I'm going to represent either a person or a company, and I'm going to do the best that I can to represent their interest. I didn't look at this as a financial transaction, but that's how they look at it because they're making an investment. And again, they could be investing in gold or cryptocurrency or stocks, but they're simply saying, we're going to take part of our money and we're going to invest it in lawsuits, because if we're successful in a lawsuit, the return on investment can be multiple times more than we would get in any of these other areas, and it's not going to be tied to underlying economic conditions. The economy could be going to hell in a handbasket, but they could still be returning, 35, 50% plus type awards.
Thank you. And nothing in this bill would prevent this type of financing for plaintiffs or defendants in Kansas. Is that correct?
Madam Chairman, that's exactly right. This is a free market solution to deal with an ethical problem in litigation.
Thank you. With that, committee, then we will turn to any neutral conferees in the committee meeting room or online. Not seeing any then. We will ask our opponent conferee, who is appearing via WebEx, to testify, Gary Barnett, Executive Director, International Legal Finance Association. Please introduce yourself and welcome to committee. And we will have 7 minutes, and I will let you know when there's 1 minute left. Thank you.
Thank you. Good morning, Chair Warren and members of the committee. Thank you for allowing me to provide remarks on this bill and your thoughtfulness on this issue. My name is Gary Barnett, and I'm the Executive Director and General Counsel at the International Legal Finance Association. Elfa represents the commercial legal finance industry, which is entirely separate and distinct from the consumer litigation funding industry. Many of the concerns I heard raised this morning surrounding this legislation do not apply to the commercial legal finance industry, which is a market-based solution to meet the needs of companies engaged in litigation domestically and around the world. Our members are passive outside investors who have no control over the outcome of the litigation. And we do not get in the middle of ethical obligations of lawyers and their clients. That tenet is specifically incorporated into Elfa's best practices, which states, Elfa members should not interfere with the performance of lawyers' duties to the courts and to their clients and respect the proper administration of justice. This is something that is very important to us at Elfa, and this is something that is very important to our members. We understand our ethical obligations, and we make sure that they are being followed by everybody. So just to explain a little bit more about kind of what our members do, the deals that we are involved with are typically in the form of multi-million-dollar non-recourse investments involving businesses ranging from startups to Fortune 100 companies, as well as law firms of all types and sizes. ILFA's members help businesses mitigate risk by providing needed financing. We finance significant commercial matters between businesses on both sides of the litigation, both on the plaintiff side and on the defendant side. The financing provided by ILFA's members allows businesses, large and small, to maintain the necessary capital to invest in their growth, driving economic development and job creation in local communities. In a free market economy, parties are at liberty to contract and should be free to do so without being forced to disclose their confidential financial arrangements, particularly to an adversary in litigation. Again, thank you for your time and for allowing me to participate today. I'm happy to answer questions at the appropriate time, Madam Chair, and I'd be happy to provide additional information to you or your committee as needed. Thank you.
Thank you, Mr. Barnett. With that, then, we will hear from our next opponent conferee via WebEx, Andrew Cohen, Director, Burford Capital. Please introduce yourself. Welcome to committee, and we'll allow 7 minutes. Thank you.
Thank you, Chair and Senators. My name is Andrew Cohen. I'm a director at Burford Capital. I have been at Burford Capital for 9 years, and my position allows me to evaluate the cases that we look at for investments. And so I have a unique position to inform the committee about our process and what we do. I should be very clear that Burford Capital is engaged in the practice of commercial litigation finance. We finance business-to-business litigation, whether that's on the plaintiff side or the defendant side or on the law firm side. We do not get involved in consumer litigation, the sort of personal injury litigations that you might have heard about this morning. Our investments are non-recourse, which means that we only earn a return when the litigations we fund are successful on whichever side we're funding. We do not involve ourselves in the control of litigation. We are very, very clear about that in all of our agreements, all of our contracts. And moreover, as a third party, we would not be able to control what the lawyers do because lawyers have an independent ethical obligation to their clients. So there is certainly no situation where a litigation funder funding an attorney could interfere with that obligation. I wanted to appear today to give the committee a chance to have information from someone who has experience on this. You have my written testimony, and I do want to make as much time as available for questions and answers, so I'll conclude there.
Great, thank you. Then with that, committee, do we have any other opponent conferees in the committee meeting room or online? Seeing none, then we will open it up for questions from the committee to the opponent conferees. Yes, Senator Baumgardner.
Thank you, Madam Chair. Just wanted to double check with Mr. Cohen again. So you provide funding for both sides or either side of litigation, is that correct?
That's
Mr.
correct.
Go ahead.
Sorry, Chair. That is correct, yes.
Okay, so in looking at this piece of legislation, does it address both sides?
Mr. Cohen?
To me, it does, because it depends on how one defines proceeds of litigation. In theory, proceeds are only, may only be defined one direction. But in a defensive situation, if we're funding a defense portfolio, there's ways of defining proceeds that would cover that as well. That being said, the level of disclosure that's being required here would be a severe disincentive for any participation by funders on either side.
Thank you, Madam Chair.
Thank you. Committee, other questions? I'm curious about that last statement, why you said it would be a disincentive.
Yes, Chairwoman. The disincentive comes from the disclosure of the litigation funding agreement. I didn't get into this in my remarks just now, but when we are diligencing litigations for potential funding, we're getting a great deal of information about the litigation from the claimant, from the claimant and the defendant, from the lawyers, from our own independent research, and we are putting all that information together into our funding agreement to craft a specific document that provides funding on timing and on returns that make sense for this specific case. Every funding agreement is very bespoke. That funding agreement is incredibly reflective of the strategy that is intended to be used in the case. It is defined as work product under relevant case law in every state that I know of. And so turning that document over to the opponents is essentially handing work product over to the opponents. And you see in the legislation, Section 4 of the same, Section 4, trial preparation material 4A. Ordinarily, a party may not discover documents, tangible things that are prepared in anticipation of litigation. Well, this new law would require handing over litigation funding agreement, which is work product, without any qualification or protection. That would be a significant disincentive to any funding of litigation on either side in Kansas courts.
Thank you. Are the funding agreements with the defendant side, are those usually, I'll call investment, or are they loans? And then the payment received from the defense side is to be paid back, you're paying back the loan, rather than when you finance the plaintiff side, you don't get anything paid back as a third-party financer unless there's a recovery, and usually that's the 33% contingency. Or so could you explain that if you're funding the defense side, it's a loan, and generally if you're funding the plaintiff side, it's not a loan, it's rather an investment where the return on investment for the funder could be zero?
Yes, Sharon. I don't think that I would characterize defense side funding as a loan either. I think that it would be characterized as an investment. It would similarly be non-recourse capital, funding the defense side costs, or essentially cabining off an amount of defense side risk. Say you're a defendant who has a liability that may be between $0 and $100 million. You are engaged in a business combination, or you want to be engaged in a business combination, and they're not interested in taking risk above $25 million. So you go to a litigation funder who can calculate the cost of that $25 to $100 million risk, and create a product that will only pay in the case of a bad outcome, or there will only be coverage in the case of a bad outcome. In such a product like that, it's still not a loan that is repayable with recourse to the underlying assets of the company. It is still not an absolute obligation. It is only an obligation if litigation goes the direction that the funders is hoping is not going to happen. So in that case, I don't think that I would consider it a loan.
Thank you. When was Elfa founded? Mr. Cohen? I'm sorry, that would be Mr. Barnett, I think.
Thank you. Elfa was founded in September of 2020.
So September of 2020. So this sounds like it's a pretty new phenomenon that we might be hearing more about. And is Elfa the main association for this type of litigation funding that you know of?
Well, there's a couple of different associations, but the International Legal Finance Association is the only association representing the commercial legal finance industry in the U.S. It's a global industry. There are a couple other associations in other countries as well, but we're in the U.S. we're the only association that represents the commercial legal finance industry. There are other associations that are on more of the consumer side involving kind of personal injury cases.
Thank you. Are your members generally hedge funds that we were hearing about and the legal finance firms, or who makes up the association?
We can, full list of our members are on our website, but it is those engaged in commercial legal finance industry. Primarily are those that are kind of pure litigation funders.
Thank you. Committee, other questions for the opponents? Yeah, Senator Baumgartner.
Thank you, Madam Chair. The proponent testimony indicated that Wisconsin became the first state to require disclosure, and that was in 2018, and West Virginia adopted a similar disclosure in 2019. So I am a little curious, from those that are opponents, do you have any information that you could share with us as far as what was the outcome? So Wisconsin now, they're 3 years of implementation, whereas West Virginia, 2 years of implementation. So how much disclosure has occurred since that time? That's my first question. And the other question is, we heard from the proponents, the issue about serving two masters and that this is in fact an ethical issue. I see that in the testimony from Mr. Cohen, he indicates that the financing does not present a conflict of interest. So could either of you speak to the ethical issue as well as what have we gleaned from Wisconsin and West Virginia as far as disclosures occurring?
Please identify yourself before you answer the question, just so those following along can determine who's speaking. Thank you.
Of course. This is Gary Barnett, Elfa. For the first question about what's happening in Wisconsin, I don't have that specific information about the kind of the level of disclosures after the fact. I'm not sure that there is much. I'm not sure at the level of commercial legal finance going on in Wisconsin, but I can take a look at that and see if I can get some additional information on that.
Thank you.
As to the second question, I don't know, Andrew, if you wanted to.
Sure. This is Andrew Cohen from Burford Capital. On the second question, I just want to stress again, we funders do not control the litigation. We do not seek to control the lawyer's behavior. At the end of the day, it is claimants and defendants who control the litigation. Lawyers may control some of the procedural aspects of the litigation, and they can continue to do that and serve ethically without any interference from funders. That is an important ethical tenet for all litigation funders. I am an attorney. I am an attorney in New York State, and my ethical obligations are very important to me, and I would never want to impinge upon those obligations of any lawyer that we're funding. So, I just want to be extremely clear about that. I will also note that I'm not aware of any significant disclosures coming out of Wisconsin, and in West Virginia, that was an expressly consumer-focused bill, so that did not affect the commercial industry at all.
Thank you, Madam Chair.
Thank you. Committee, any other questions? Seeing none then, thank you to all our conferees who have appeared today, both in person and on WebEx. And want to address the question about submitting corrected testimony. Committee doesn't allow for correction of written testimony. I think that the typographical error has been addressed in testimony, so there won't be any requirement for resubmission of testimony based on questioning that occurs in committee. We don't generally allow that. So we have corrected that on the record through the testimony today. So appreciate pointing that out, and both the pointing it out and the correction on the record in testimony. With that then, committee, please be advised that we are meeting all days this week, including Friday, and there will be a revised agenda put out today, and wanted to give some notice that we will be hearing additional bills this week that are not yet on the agenda, but please look for those this afternoon and have your testimony from conferees prepared and submitted in a timely fashion. With that then, committee, we are adjourned.